problems in the Second Circuit. For if there are, they are certainly a barrier to litigants' access to the courts and to equal justice. How these barriers operate is vividly illustrated by a June 1995 California Court of Appeals decision, which is worth noting because even though this is a state case, the opinion relies and cites heavily the report of the Ninth Circuit Task Force. The case is called Catchpole versus Brannon. It was a bench-tried sexual harassment case involving an alleged rape by a supervisor and a plaintiff who did not visibly resist. It's called Catchpole, C-A-T-C-H-P-O-L-E, and I'm going to give you a written version of my statement that will have the citations in it. In this case, the judge was so convinced of the myth that a woman who was truly being raped would physically resist that even the supervisor found that this judge's behavior and decision exemplified every negative attitude towards sexual harassment cases results in gender-biased decision-making. This judge called sexual harassment cases, quote, detrimental to everyone concerned. He said this particular case was nonsense. He showed extreme irritation having to listen to the plaintiff's witnesses, and he subjected the plaintiff alone among all the witnesses to a scathing interrogation. This case was appealed on the specific ground that the judge's gender bias. I digress a moment to say that this was a case that really stunned me. Earlier this year, there was a report of two men being arrested in LAX who did not complain of sexual abuse of a 50-year-old on the plane. And, I mean, the case, the allegations are appalling, but I mean, who thinks about a case like that winding up in federal courts? And yet it did, and there was a very involved on the underlying causes which bring these cases into the courts are violence against women issues. The forfeiture case that I mentioned earlier was sent to us by Alabama District Court Judge.
If any manifestations of bias are occurring in the courts of the Second Circuit, we want to know about it and take steps promptly to eliminate such occurrences. In closing my remarks on the 1980 Act, two other recommendations made by the National Commission deserve comment. These relate to the National Commission's findings that only a portion of instances of judicial misconduct ever resulted in complaints being filed under the 1980 Act. The National Commission found that most people, federal litigators included, do not even know about the 1980 Act, and moreover, that there is a widespread fear of retaliation on the part of the lawyers by dismissals, because the dismissals tossed out these complaints. I would like to make one further point, and that will be addressed more in my co-presenter's testimony, and that is what happens
answer to
retaliation.
how to deal with the fear of retaliation. And that lawyer asked her.
I feel like, well, myself, my mother,
This is Elena Sassow and Dora Sassow, and then somebody from the court. Did you see the cameras over there? There's 3 people with cameras. What time is it? It's 3:41 p.m. They are 11 minutes behind schedule at least. This is Tuesday, November the 28th, 1995. This man is a reporter.
Ms. Sassow, let me just say before you sat down, let me just say we appreciate your comments. We appreciate the time and energy you put into the presentation.
Oh, how nice. This is Judge Walker,
Serious discussion.
Second Circuit. She left me this. All right, thanks. Where are they?
Good afternoon, Mr. Chairman, members of this task force panel. It is Doris Sansella. I appear here as director and co-founder with my daughter Elena of the Center for Judicial Accountability, Inc., a national non-profit, non-partisan organization working to improve the quality of our judiciary, federal and state. The subject of this hearing was sourced outside the four corners of the courtroom. In other words, if the bias of the basis of the recusal application is that the proceeding at issue, that the judge has engaged in an oppressive, bullying, insulting behavior, has disregarded black letter law, has falsified the
Doris
facts,
Judge Walker, Second Circuit.
in other words, when he has
2 p.m.,
engaged in all the
28,
misconduct
1995.
popularly believed to be biased, that judge, under accepted judicial construction, need not recuse himself. The state
No, the light doesn't flash.
will provide copies to each of the members of the panel, as well as the references I made to cases and recusal motions. I am going to provide you with copies of them as well.
As I mentioned, it is part of the work that's supposed to look at existing evidence for relief bias. So, testimony is relevant.
Thank you for your attention. If I may, I would like to respond only to the question that you put to my daughter concerning possible assistance in advising.
Turn it on.
Then judicial whistleblowers must have the protection, the maximum protection that can be afforded by our system, so that
It
they
says
are not
talking to Walker,
going to
saying
be
that
injured,
lawyers who whistleblow should
ruined
have
when
protection.
they do their job, whatever they do.
Now, I have a TV program, Judge Walker, and it's on 11 different cable systems in the New York metropolitan market. I wish to thank you for this opportunity that you've given all of us, and to be heard on enterprise judges. May the words of our mouths and the meditation of our hearts be acceptable unto you, our God, our strength, and our Redeemer. I am fully aware of the technical rule for public speaking. If you don't strike it well, in 15 minutes, stop it.
You're going to be striking it at 8%.
Yes,
It's
8.
even more exciting.
Maybe 7. Now, first is today's joke. The lawyer said to the judge, I want a new trial on the basis of new evidence. And the judge says, what's the new evidence? And the lawyer says, I just found out my client has another $3,000. Now, the rest of what I have to say is kind of sad. They taught us in high school, folks, that if your rights are violated, you go to court and get justice. I went to court over 40 times. 40 and 4 in the past 5 years, and justice I did not find, but I found tender Bibles instead. I found that a judge always rules for what is best for the judge. The judges look out for one person and one person only, and that is the judge. Whether ruling in favor of plaintiff or defendant. They come up with all of these lofty citations, and then in the end, they rule by the seat of their pants. I have found that judges and lawyers break more laws than defendants. October the 26th, 1995, Glendora said, but Judge Bryan, Federal Rules of Civil Procedure Rule 30b-2 says, I can videotape an audio tape the deposition. Judge Bryan said, The rules are no good. And he sent me off on a deposition that cost $490, which is $50 more than my Social Security check. In the Judge Smith Court on November the 7th, 1995, Tuesday, Glendora Court Local Rule 2, then sent Judge Smith off to the bench and into her chambers to look up Rule 2. And then I said that I had scheduled a 26F conference, and I would like to have it after the hearing. And Judge Smith had to look up Federal Rules of Civil Procedure 26F. Well, Glendora, pro se, was tired of reading the law to judges and lawyers. Now, before I go on to the next gender bias, I would like to pause for comic relief and tell you about a colleague of yours, Judge Frederick B. Lacey, Jersey District Court, in his paper on the role of judges in settlement. He quoted Old English law. I would like to pass on his Old English law to you. It is, a bumper of good liquor will end this case quicker than justice, judge, or vicar. A bumper of good liquor will end this case quicker than a justice, judge, or vicar. Now, Glendora moves on to the worst bias of all, the bias against female pro se. Glendora has, by the Constitution of the United States, a right to be a pro se, and a judge pledges to support the Constitution of the United States. Glendora has no faith in lawyers, excepting 10 lawyers out of the hundreds that she knows. They have sold their souls. They are liars for hire. They make their living liar. Ergo, Glendora will not have a lawyer, particularly when she reads the cases in the Federal Judicial Center. These books, Federal Judicial Center. These books, sanctions imposable for violations of federal rules of civil procedure, and the discovery problems in civil cases. And then she reads about plaintiffs whose cases are dismissed because their lawyers are negligent or inept or just plain crooked, and that the Second Circuit supports the feeling that a plaintiff is responsible for his lawyer chosen, and then the United States Supreme Court comes along and says, you're right, Second Circuit or Ninth Circuit. Glendora is pro se and judges are pro-liar. It is not right in American courts to be anti-pro se and anti-female. There is one exception. I cite this to you with great pride and solace. Now, on January 11, 1995, your court, Judges Minor, Van Drakeland, and McLaughlin of the Second Circuit vacated and remanded Judge Bryant's dismissal of Glendora's case with this caveat. Pro se's case should not be dismissed unless it is proved beyond a doubt she has no claim, particularly in civil rights cases. Now, just between you and me, I think that this order would have been reversed. It was vacated and remanded. I think it would have been reversed had it been a lesser judge than Bryant the Giant. Judges are biased in favor of big business also. May I mention that? Thank you. Judge Johnston, Harrison Town Court, Glendora versus Curly Gannett. Also Judge Fox, our magistrate judge up in White Plains, Glendora versus Gannett Antitrust. Also Judge Broderick in Glendora versus Gannett. And also Judge Broderick in Glendora versus Charlesville Cablevision. Judges throw justice to the wind and in favor of rulings for other judges. I mentioned specifically Judge Patel, now banished to Connecticut, and Glendora versus Judge Conrad Duberstein and Judge Robert John Hall. I don't know if you know those judges, but they're bankruptcy judges in the Eastern District. Even female judges are biased against female pro se's. I think the girl judges are as bad as the girl judges. Judge Joanne Freya, Judge Smith, Judge Gans, Judge Shaver, and Judge Sarah Lee Evans. The most blatant evidence about biased judges before you somebody 5 years ago who was well-to-do, and today, after being ground up to pieces seeking justice before biased judges, Glendora is now a former populist. Judge Crusade declared Glendora a former populist August 23rd. Now, the greedy grubby lawyers are voting for their tea-sucking, and they're doing just fine. And as Glendora said on television practically every week, that the worst consumer ripoff in America today is the courts. Continuous with these bias problems is the problem that judges are not qualified. Judges in the Westchester Supreme Court who are paid $113,000 a year do not know what they are doing, simply are not qualified. They do not know statutory law, they do not know case law, they do not know what is going on in the courts day-to-day, week-to-week. And they are scared stiff to be audiotaped and videotaped. They don't want the public to see what is going on. It is not right to frisk us for tape recorders in security. It is not right for male security guards to frisk females. I wish to stop here and ad-lib that you, Judge Walker, deserve a great deal of credit. You are enlightened to allow me to bring my video camera in and my audio tape recorder in. I truly appreciate that. I want to tell all my TV fans about that.
By the way, I'd like to say that your testimony, your interesting testimony, you've still got a minute. So I don't want to
What did you say though? I still got a minute. Is that what you were telling me? So, well then if I have a minute, I want to say about the bias of law clerks. Not so much in the federal court, but in the state Supreme Court. The judges don't know anything. They depend upon their law clerks for all of the information. Consequently, the law clerks end up bossing the judges, and then the law clerks end up bossing the public. Everything. And I just don't take that. And that's how I lost many lawsuits. One that I'm female, two that I'm pro se, but three I won't take their gun. And they're accountable to nobody. You heard there were Sassower, Commission of Judicial Conduct does nothing. Judge Kahn didn't even listen to her case. I was an intervener in that case. He didn't even listen to it. How many seconds do we have?
We have another 7.
And a state Supreme Court, folks, is no better than its appellate division. You go before the appellate division, well, 4 judges, not one of them will look a pro se in the eye. Not one of them will ask a pro se question. This was true in the second circuit, except for my Van
Do you have any witness submissions?
No. You can hear it on TV.
Well, that may be what the alternative, because at this point we have a lot of other witnesses.
Yes.
Who are waiting.
Are you going to give us a free VHS the way Lawrence Tish does at the shareholders meeting?
We don't have the same resources.
Okay.
All right, thank you.
Yeah, no, one more thing. I want to tell you, do you know what the judge said to the dentist? Do you swear to pull the tooth, the whole tooth, and nothing but the tooth? So.
All right, thank you.
I want to show you some more marble. This is quite ornate. This is all marble. And what time is it now? It's 4:27 p.m. And take a look at these doors. It was too dark in there, I couldn't show you the elaborate carpet. You know, up in the White Plains, they distinguish the 6 courtrooms with the different color carpets. But here, they have to do it by patterns because they run out of colors with all of the courtrooms. So now we will head for the Lincoln, and I haven't eaten. I have abstained from eating. I'm supposed to eat at 3 o'clock, but of course I couldn't leave. 5.
By a car. Came up from the
Did you hear Franklin say that a pedestrian must have been hit by a car? They're picking him up and putting him into the ambulance? Oh, that's awful. God bless you. Dear pedestrian. Pretty fancy elevators. It really is elaborate. You gotta give them credit. In White Plains, the courthouse, the elevator talks to you, a woman talks to you. Says this car is going up. Here's the accident. Now, we'll get across here and give you a view. Here you have 500 Pearl Street. Now this is the old courthouse. No, yeah. What we door closed? Yeah, we came out the back door. That's the front door over there. Okay. Anything else?
The picture of the sign to put up there.
This is the Supreme Court of the state of New York. I mean, excuse me, yeah, state of New York, but county of New York. Yeah, the trunk. I mean, the hood. There's the old Victory Courthouse, our federal courthouse, the Second Circuit, where we won the big victory against Cablevision.
That accident down there in Manhattan. I feel so sorry for them. The fight between Virginia and Felicia. Felicia's a stray kitty we adopted, and Virginia is fighting for her domain. But then Virginia has to realize that Katie had to do the same thing, and that Katie was Felicia picking on Katie. The other way it was Virginia picking on Felicia. But Jeannie has to realize that Katie was upset when we rescued her, Virginia, and Katie has to realize that Carmino and Harrison were upset when we rescued Katie. That was a terrible thing about that accident down there in Manhattan. Also about the beautiful courthouse and those elaborate courtrooms. You would think, though, that they would have more light. Did you see how dark that videotape was? And you would think, too, that they would have better sound so that people could hear. The judges didn't use their microphones, you couldn't hear. Folks, when you're asking for a Glendora Happy Book, be sure and leave your telephone number so that you can be called up, because all of these Happy Books have been returned. Probably so. Did you know what the hypochondriac had put on his tombstone? The hypochondriac had as an epitaph, "See, I told you I was sick." And there was an ad in the newspaper, umbrella for sale by lady with 2 cracked ribs. And I went into the store and he said, "I want to buy a mattress," and the clerk says, "a spring mattress," and the bachelor says, "No, I want a mattress that I can sleep on all year." I would like to tell you that when you request for a Happy Book, please give your telephone number so we can call up and verify your address. All of these Happy Books came back because the addresses were wrong. As they were heard over the recorder, they were wrong. Each one of these costs 55 cents, and also it means that you don't get a Happy Book, and that was the reason for your call. So please give your telephone number and your address. We're reporting on the law breaking of Walsh, Alpucci, Larkin, and of their lawyers, Wilson Bave, Comboy Koza Cousins, Odell McGrath, Karamitzos, and Bruce Bendish, and of the courts, Harold Wood, Paul Carlucci, and Angelo Ingracia. Nothing got done on the DHCR. The DHCR has done nothing about giving us a rent reduction for reduction in services. Nothing. The telephone call that I just got before I sat down to report to you was from my program in Manhattan, 8:30 a.m. on Channel 16. David Cohen, he says, "What do you do?" He says, "How do you know the lawyer is telling you the right amount for which he settled the case? How do you know that the lawyer settling the case for $100,000 isn't really settling it for $200,000? How do you know what the correct amount is?" Well, if it were myself, I'd call up the client. But I told him that you can't trust lawyers and that these things go on forever, and the reason they go on forever is that every paper a lawyer gets out, every lie he writes, he gets paid thousands of dollars for. So he's got a very good point. All that I could suggest that if it were my case, I would go to the law library and I would go to the Association of the Bar in the city of New York. I would complain and I would tell the lawyer to tell him the truth. Now, On the New Wall lawsuit, can't get a chance to work on it. Cannot get a chance to work on it. This is going to be a petition to the United States District Court pursuant to Rule 27 to take depositions, to do discovery before the action begins, which is a very sensible idea. And all of the clients in this, all of the defendants in this are, of course, Walsh, Alpucci, and Larkin, and their lawyers, and the Judge Wood and Judge Ingracia, and possibly the White Plains Police, and something else I was going to tell you about that. So the questions to ask each defendant are pretty well listed. It is a petition. You take it to the United States District Court. You're given a judge, and then the judge decides whether the petition is going to be granted. So there's no chance to work on that. 25 hours went into this. This is Glendora's reply brief to the Appellate Division, 2nd Department, Supreme Court of the State of New York on Glendora versus Daniel Walsh, Roberta Walsh, James Walsh, Nella Alpucci, and Theo Alpucci, but this is the Larkin branch of it, and this reply brief did get out on Monday, November the 27th, 1995. It was served upon the crooked lawyers, Bendish and Wilson Babe, and it was 9 copies were sent to the Appellate Division. And what was the expense on it? I guess the expense was something like $25. $25 and 25 hours. And it says to be argued by Glendora, 15 minutes requested. Table of contents is Glendora refutes Karamitso's lies, which she euphemizes as facts. Glendora scrutinizes Karamitso's procedural history, and then comes the argument and the points. And as before, folks, we won't read you the points, other than the points on their heads. We won't read this to you. We'll just go, the contents, table of contents. We'll just read you the text. Glendora refutes Karamitso's lies, which Karamitso euphemizes as facts. The causes of action of Glendora versus Daniel, Roberta, and James Walsh, Nella and Theo Alpucci, and Andrew and Kevin Larkin are the violation of 4 laws 3,000 times. These people have violated 4 laws 3,000 times. Now, the first law is harassment. A person is guilty of the offense of harassment when, with intent to harass, annoy, or alarm another person, he uses abusive or obscene language, he strikes, shoves, kicks, or otherwise subjects him to physical contact, he engages in a course of conduct, or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. Intentional infliction of emotional disturbance with no physical effect is the second law they've broken. The third is insulting and abusive language, and the fourth is violation of the White Plains Noise Ordinance. Karamitsos cannot count over 2. These 4 laws were violated not by 2 defendants, but by 7 defendants, not by 2 infants, but by 3 infants, and not by just the infant, but also the parents who were as infantile as their badly parented infants. Karamitso's lies, she has told the following lie repeatedly. The plaintiff alleges that the infant defendants who reside in her apartment complex have negligently and intentionally caused the plaintiff emotional distress by such activities as, and then they list the activities that don't break the law, instead of listing the activities that do break the law. You see how lawyers get paid for lying? This man who just called from Manhattan, he said, I like your show. He says, I realize that what she's saying is true. He's been in it, and I'm sure many of you watching now have been through it. Glendora says this is an infantile lie by an infantile lawyer, Alexandra Karamitsos of Wilson Bay. It is also stupid, repetitiously stupid. The record is by such activities as, this is the truth: the breaking of the law by the Walsh, Alpucci, and Larkin families, the White Plains Noise Ordinance, April the 11th, 1993, Easter. And this is the law. This is the White Plains Noise Ordinance. Yelling, shouting, hooting, whistling, or singing at any time or place so as to annoy or disturb the dwelling or other residents. Excuse me, I left out. So as to disturb the quiet, comfort, repose, health, or peace of persons in any dwelling or other residence. That is the law that was broken initially. And when Glendora stood up for her rights and began videotaping her evidence that Wood never saw and that Ingracia never saw, and yet they rule. They rule politically. Instead of reforming, said hoodlums started a long campaign of retaliation. More law-breaking, harassment, vandalism, thievery, abusive and insulting language, horn-blowing, fright, mental disturbance, and littering. That's the whole thing in a nutshell. Defendants in their ignorance and arrogance have committed more than 3,000 tortious acts. Wilson Babe, Conboy, Koza, Cousins, McGrath, Odell, Karamitsos, Bendish, Judge Wood, and law clerk Paul Carlucci and Judge Ingracia have committed more than 3,000 violations of the laws listed in Glendora's appellant's brief of October 20th, 1995, which was read to you. Table of authorities. Here's another lie. Karamitsos calls the facts. The parents of these children have also been named in the lawsuit for failure to supervise their children's activities. Well, no. The parents of these ill-bred children were sued for violation of the same 4 laws and for coercing and encouraging their children to continue their law-breaking. Isn't that a great parent? It takes a great parent to do that, right? Glendora says the Appellate Division 2nd Department is being used for lawyer training. Karamitsos isn't experienced enough to go to the Appellate Division by herself. She's too little to go by herself. Karamitsos writes, I will not burden the court with any further details. In other words, she won't tell the court the truth concerning plaintiff's allegations as they are fully contained in plaintiff's voluminous record on appeal. Yes, it's their record. It's their bad record. 2,200 pages went to the Appellate Division. You saw them. At a cost of $1,000. Glendora, here is some progress in lawyer training. There should be a comma before as. Glendora's record on appeal does contain fully what happened. The record speaks for itself. 4 volumes, 2,200 pages, 127 hours, and $1,000. The Appellate Division should have granted Glendora's motion for informa pauperis. Her only income is Social Security, a little more than $400 a month. Social Security for September and October was used to perfect this appeal October 20th, 1995, Friday at 4:45 p.m. Now, Glendora scrutinizes Karamitsos' procedural history. Karamitsos writes, and I quote her so-called procedural history, and Glendora says, the basis of both motions, Karamitsos writes, were the plaintiff's pleadings, correspondence, bill of particulars, deposition testimony, and her opposition papers. Glendora, in doing so, Judges Wood and Ingracia ingratiated themselves in making the political decisions in favor of these defendants. Judges Wood and Ingracia ingratiated themselves with politically powerful Wilson Babe, but violated their oaths of office to support the Constitution of the United States, equal protection of the law, and due process. No trial, no jury, no evidence taken, no witnesses sworn. It's great. It is great courts. I say if they can't run the courts, then get out and let somebody who can run them. They violated the New York State Constitution, in Gracia and Wood, defendants and lawyers, and they violated all the laws Glendora listed in her table of authorities appellant's brief of October 20th, 1995, Friday. Both judges want JHO appointments. That's Judicial Hearing Officer. When a judge wears himself out on the public all these years, he should retire at 70, but he keeps getting 2-year extensions until he's 76, and then that's not enough greed and avarice and acquisition for them. They want to be judicial hearing officers because judicial hearing officers make $250 a day of your money. Both judges want JHO appointments and know they had to placate Wilson Babe to get these appointments. Wilson Babe was on the side of the lawbreakers, so Judges Wood and Gracia, out of avarice and acquisition, 3, throw justice to the wind. Both failed to decide the case on its merits. No witnesses were sworn, no evidence that it is on 8 hours, but it is on 8 hours of videotape, and Gracia or Wood didn't see that. Oh no, that would have convicted them. Oh, we can't have that. We got to rule in favor of Wilson Babe so they'll get us these JHO appointments. No testimony was taken, there was no trial and no jury. All this talk about sanctions is stupid. How are you going to sanction an informa pauperis? Glendora has been impoverished by these crooked lawyers and corrupt judges. There is no legal basis for sanctions. The law clerk, Paul Carlucci, who kept threatening in infantile manner, has lost his job and is out of the Westchester County Courthouse. Glendora wishes the same on Judge Wood and Judge Gracia. Kara Mitzels is not fully familiar with the facts and circumstances. She babbles. On July 24, 1995, the Honorable Judge Gracia also denied plaintiff's motion to renew and re-argue in the related action. Well, first of all, there is nothing honorable about Gracia. Second, he granted Glendora's motion to vacate, not renew and re-argue. Third, he said nothing would change his mind. So what point was there in the face of this bizarre statement in pursuing a vacatur? The system is bad. On November 28, 1995, Tuesday, noon to 8 p.m., there is a hearing in the United States Courthouse, 500 Pearl Street, Manhattan, on biased judges. Glendora will get her 15 minutes to have her say. And I did. And it was about Wood, and it was about Gracia, along with all the other corrupt judges in the Westchester County Supreme Court. Kara Mitzels writes, September 15, 1995, plaintiff made a motion for an order to appeal informa pauperis, which was denied by this court on November 8, 1995. This office was served with appellant's brief and voluminous record on appeal on October 20, 1995. Glendora, this is duplicative, unnecessary, and infantile. It is a space filler and a fee sucker. This court is being used for lawyer training. Kara Mitzels goes into point 1 without any title, no argument. You really should stop reading her respondent's brief. It will only get more infantile. And now the argument starts, and we are up to page 11. Starts her argument. This is point 1. The court below improperly granted summary judgment because the judge, Harold L. Wood, wanted a JHO appointment. Kara Mitzels writes, in dismissing Glendora's case, the court held that as a matter of law, the plaintiff's claim for intentional infliction of emotional distress must fail, since such a claim requires extreme and/or outrageous conduct, which actually causes severe emotional distress. Thanks, Kara Mitzels, because that's exactly what happened. How would judge know if the conduct was extreme or outrageous? He never saw the evidence. He never saw the 8 hours of videotapes documenting the extreme and outrageous conduct. This is an insane way to conduct a court. It is a good thing he is through in a month. December 31st, 1995, goodbye, Judge Wood. Coming back as a JHO at $250 a day because he ingratiated himself with Wilson Babe. Kara Mitzels writes in her last paragraph, page 3, the court found that as a matter of law, the actions alleged by the plaintiff in her pleadings and opposition papers and as testified to at her sworn deposition do not rise to the level of extreme and outrageous conduct. Glendora, the court found as a matter of fact that it didn't kiss the shoes of Wilson Babe, it wouldn't get any more political favors, particularly that JHO plum. Kara Mitzels continues and fails with, the court reached the same conclusion for the negligent infliction of emotional distress claim and also noted that the plaintiff had failed to substantiate with medical proof any injuries allegedly sustained. The court reached the same conclusion for the record, Glendora says, for the second claim that it would not get a JHO appointment unless it submitted to every evil, peremptory summons or political tyrants of Wilson Babe. The law says intentional infliction of emotional distress with no physical effects. This is Glendora's claim. Karamitsos knows she is off base. She has pulled this lie before. She should be sanctioned to the limit, and Wilson Babe has the money to pay sanctions. Glendora claimed no physical effect. If there is no physical effect, there is no medical examination. And here is the law, folks. This is a quote from American jurisprudence. Emotional distress resulting from another tort. In cases involving intentional or wanton or willful torts, and certainly this is the case with Walsh, Alpucci, and Larkin, recovery is allowed for mental anguish unaccompanied by physical contact or injury. Frankly, I, a pro se, am tired of reading the law to judges and to lawyers. Wilson Babe should know this. Judge Wood should know this. For mental anguish unaccompanied by physical contact or injury, or for a physical injury received solely as a result of the mental anguish. In an action for a tort based on malicious and wrongful acts, which this was, of the defendant, three defendants, Walsh, Alpucci, and Larkin, where the acts result in substantial damages, as this did, the jury is entitled to consider. Well, this poor thing never got to the jury because Wood wanted a political appointment. Not only the actual money damages, but also such other damages as necessarily arise out of the acts, including damages for mental suffering and anxiety, if the effect of such damage is to produce suffering and anxiety, and when there is a guarantee of genuineness in the circumstances surrounding the alleged mental disturbance, recovery may be permitted. Well, Wood didn't want recovery. He wanted a JHO appointment. On her page 4, Karamitsos continues her whining. Clearly, the lower court's decision is correct as plaintiff's allegations fail to even approach the requirements necessary to maintain a cause of action for either intentional or negligent infliction of emotional distress. Clearly, the lower court, Glendora says, Harold L. Wood, is incorrect. How would the court know? It didn't see 8 hours of evidence on videotape. It didn't call any witnesses. It made a decision it should not have made. It decided matters that a jury should decide. Defendants committed every requirement for a claim of intentional infliction of emotional distress with no physical effect. Karamitsos says. But Glendora says, turns it right around. There was extreme and outrageous conduct by Walsh, Alpucci, and Larkin. You've seen it on videotape. There was an intent to cause or disregard of substantial probability of causing severe emotional distress. 3, there was a causal connection between the conduct and the injury. 4, the conduct resulted in severe emotional distress. Defendants accomplished each one of these 100%. But how would Judge Wood know? He never saw 1 inch of videotape footage. Even if he had, it would not have mattered. He had to be obsequious to Wilson Babe to get their political favor. He had to kiss their shoes. No matter how much of a fool he made of himself, and a fool he did make of himself, his record is there. 2,200 pages, public record. You can read it anytime, but it's been read to you already. Karamitsos writes, with respect to the negligent infliction of emotional distress claim, in order to survive a summary judgment motion, the plaintiff must demonstrate a duty running from the defendant to the plaintiff, a breach of that duty. Well, Glendora says, she already showed that Andrew and Kevin Larkin had a duty toward her, and now I'm going to quote the law to you again. New York adheres to the majority view, which expressly recognizes the existence of an independent tort of intentional infliction of emotional distress. Why don't you read the law, Koza Cousins, Comboy, and your little underlings, Odell, Karamitsos, and McGrath? Why don't you read the law, Harold Wood and Judge Ingracia? A cause of action for intentional infliction of severe emotional distress may be maintained. There may be recovery for the intentional infliction of emotional distress without proof of the breach of any duty other than the duty to refrain from inflicting it. New York jurisprudence. Glendora demonstrated the breach of that duty by Harrison police officer Andrew Larkin and his poorly parented son, Kevin. 8 hours of videotape evidence. Andrew Larkin is no longer with the Harrison police force. September 1st he was out. Kevin climbed the outside wall and looked into Glendora's bathroom in full view of Andrew Larkin and wife Patricia. Andrew menaced Glendora in the basement laundry room. He always carried a gun. Andrew Larkin was truculent to Franklin. We never went out nor returned home without fear of our physical well-being or safety. The Wood Court incredibly turned down 3 motions for temporary restraining orders and preliminary injunctions. The selfishness of the Wood Court was and is grotesque. And add to the following. 1, this is the law again we're quoting. 1 who by extreme and outrageous conduct intentionally or recklessly causes severe emotional distress to another is subject to liability for such emotional distress. Liability is found only where the conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decencies as these people did, as you know the record, and to be regarded as atrocious and utterly intolerable in a civilized community. And you've seen the footage on all of that. And the malice and the vindictiveness and the steady campaign day in and day out, Glendora says, and now I quote the law again, where severe mental pain or anguish is inflicted through a deliberate and malicious campaign of harassment or intimidation. And this is what happened, and you saw it. A remedy is available in the form of an action for the intentional infliction of emotional distress. Where defendant's conduct is extraordinarily vindictive, it may be regarded as so extreme and outrageous as to give rise to a tort cause of action for emotional distress. And all of this Wood ignored so he could get his JHO appointment. Would you like to take an oath to support the Constitution of the United States and the Constitution of the State of New York and double-cross it? Double-cross the United States, double-cross the state of New York, double-cross the public, double-cross yourself. Would you like to do that at 75 years old? Particular acts are actionable when done without legal justification, or as the rule is sometimes stated, when done maliciously. And you saw plenty of that. An action will lie for malicious acts and words where they are calculated to produce and where they do produce damage. They were calculated. They did these things on purpose, just to do that. We have 8 hours of videotape, which you didn't see, Judge Wood, and which you didn't see, Judge Ingracia. But that doesn't make any difference. It's only evidence. It's only witnesses. It's only a jury's job to decide these things. What do you care? And this was all done by Kevin and orchestrated by his father. And this deliberate campaign was inflicted on 2 seniors, one now 67 and the other 76. But what did Judge Wood care? He greedily wanted that JHO appointment. He would give anything for it, including his oath of office. Here is more law, insulting, and abusive language. This is again from American jurisprudence. Excuse me, I keep saying American jurisprudence. It's New York jurisprudence. National background. New York adheres to the majority view which holds that insulting or abusive language can be actionable. Hear that, Judge Wood and Judge Ingracia? If it is sufficiently outrageous to a person of ordinary sensibilities, as that was. Do you have ordinary sensibilities? Both where the language is alleged to have caused purely emotional distress to the person to whom it is directed. It has been held that even in the absence of a contemporaneous bodily impact or injury, you hear that, Karamitsos? Or of acts constituting an assault, a cause of action is properly predicated upon a mental or emotional disturbance, or upon a bodily injury or illness resulting therefrom, which is produced by disturbing utterances such as profane, insulting, humiliating, or abusive language, and we have that from all of the defendants. All 7 of them. Roberta, Daniel, James Walsh, Theo, Nella Alpucci, Andrew Larkin, and Kevin Larkin. It's all on tape. Generally, recovery in absence of physical impact. Freedom from mental disturbance is a protected interest. Damages may be recovered on a cause of action for emotional disturbance. New York law allows recovery for mental disturbance in the absence of a physical impact. Accordingly, the presence or absence of an impact is not the decisive factor. Wilson Babe, Koza Cousins Conboy, Odell, Karamitsos, McGrath, they all should know this. They're very deficient at knowing the law. They're very deficient on writing a paper. Most of them are illiterate. But given that one thing, The other thing is that they deliberately lied. Deliberately lied. Well, that's what a lawyer gets paid for. What'd you do today, Daddy, all day at work? I lied. Daddy, how do you make the money to send us through college and pay for our food and our clothing and our shoes? I lie. Glendora will succeed in a just court in her action for intentional infliction of emotional distress with no physical effect because she can show, 1, that defendants' conduct was so outrageous and shocking as to exceed all bounds of decency as measured by what the average member of the community would tolerate. 2, she can show that defendants' conduct caused severe mental distress to plaintiff and that defendant acted with a desire to cause such distress. Directly, and under circumstances that made it certain defendant knew that mental distress would result. They just stood right out there and did it. Glendora set forth facts showing extreme and outrageous conduct on the part of defendants that intentionally or recklessly caused severe emotional distress to plaintiff. Glendora's complaint stated a cause of action for intentional tort of outrageous conduct causing mental disturbance where the conduct charge was so shocking and egregious that it exceeded all bounds of decency and was of such a character as to give rise to liability. And here's some more from New York jurisprudence. A complaint which purports to state a cause of action for the intentional infliction of mental distress need not plead special damages nor allege that defendants' harmful acts be motivated solely by malice. Exemplary damages may be recovered in a common law action for intentional harm for mental disturbance and offense to a plaintiff's personal dignity resulting from an assault and direct violent conduct. Evidence. To succeed in an action for intentional infliction of emotional distress, plaintiff must prove, and it was the 3 things that I just read you, and Glendora has this evidence. It is 8 hours on videotape. It is on 3,600 pages of logs, exhibits of the court. It is on audio tape. We're on page 17 now, and we move to point 2. The tail wags the dog, the law firm wags the court. But Judge Wood ignorantly ignored it. He had an axe to grind, just as the tail wagged the dog. The lawyers, Wilson Babe, Comboy, Cozen Cousins, McGrath, Odell, and Karamitsos wagged the court. Point 3. Karamitsos defaulted. Add to this, Karamitsos defaulted. Glendora should have won in a real court a default judgment hands down. The summons with complaint was handed personally to Andrew Larkin, 2 copies, one for him and one for Kevin, on November 11th, Armistice Day, 1993, Veterans Day. Karamitsos never answered until January 5th, 1994. Judge Wood never should have denied Glendora's motion for default judgment. And they put up no defense at all. Why? Because Judge Wood wanted a JHO appointment, and Wilson Babe law firm, politically influential, was going to get it for him. The Larkins knew they were guilty. They fled in July 1994 as soon as Kevin finished the school year. They moved. Glendora investigated and found out that they moved to Harrison. Kozer lied and said they moved to Maryland. In September 1995, Andrew Larkin was retired from the Harrison Police Department. Wilson Babe, Karamitsos are guilty of insurance fraud. Their client, General Accident, and the CEO of General Accident is Walter Farnham in Pennsylvania, does not cover the Larkins for non-physical injury, nor for intentional infliction of injury. Here you have Wilson Babe taking the insurance company's money to defend Larkin when he has an insurance company that doesn't cover him for these two causes of action: mental injury and intentionally inflicted injury. Judge Wood did nothing about this. He did not want to upset the precarious political relationship he had with Wilson Babe. It is crooked lawyers and corrupt courts. Point 4. Wilson Babe talked to the appellate division the same way they talked to Judge Wood. Wilson Babe talked to the appellate division, second department, the same way they talked to Judge Wood, Judge Coppola, and the other judiciary they control in the Westchester Supreme Court. They are the boss, and you are the underling, meaning the appellate division. Point 5, Koza and Wood socialized at Pearl River dinner. There was a dinner in Pearl River in October 1995, and two of the revelers were Harold L. Wood and Michael Koza. Point 6, Karamitsos ignores Glendora's fourth cause of action, so Glendora wins. Note carefully, if you have not already, Karamitsos fails to deal with Glendora's fourth cause of action, harassment of Glendora by Kevin and Andrew Larkin. And again, here is the legal definition of harassment. And they did all these things: push, shove, abusive and insulting language in a public place, and pursued a course of conduct which alarmed or seriously annoyed another person and which served no legitimate purpose. Point 7, Larkins did engage in extreme and outrageous conduct which resulted in fear of physical harm. Karamitsos writes, furthermore, liability only attaches if the defendants engage in extreme and outrageous conduct, which they did, which is substantial, which it was, and results in physical harm or fear of physical harm, which it did. Nella Alpucci hurt my arm. Roberta hurt my head. Can you imagine these people actually getting into physical contact? Glendora says, thanks. This is Karamitsos. This is exactly what the defendants did. Glendora has the proof. Judge Wood turned his back on Glendora and his face to Wilson Babe. Point 8, but Judge Wood never saw the evidence of 8 hours of videotapes. Karamitsos writes, plaintiff's pleadings, bill of particulars, sworn deposition testimony, opposition papers to defendant's motions for summary judgment were all considered, but not the videotape, not the evidence, not the witnesses. Glendora, how about the videotaped evidence, the witnesses, the jury? Are we missing a few elements of a just court here? Point 9. Karamitsos writes, furthermore, Judge Ingrassia in his decision of May 31st, 1995 in the companion case reached the identical decision and granted the co-defendant's motion for summary judgment as well. No, well, nor did Ingrassia see the videotapes or hear the witnesses. They really know a lot about running a court, don't they? Glendora, yes, for the identical reasons, and it was appealed for identical reasons also. The entire courthouse is controlled by Wilson Babe. Point 10. And we're up to page 20. Sanctions and costs must be imposed upon defendants Andrew and Kevin Larkin and upon Wilson Babe, Comboy, Koza, Cousins, McGrath, O'Dowd, and Karamitsos for 1. Perjury, 2. Manipulation of the courts, 3. Violation of the judiciary laws, 4. Fraud, 5. For denial of due process, 6. For conspiracy, 7. For obstruction of equal protection of the law, 8. And for baseless defense when they have no defense. Defendant's lawyer's selfish pursuit of lying, stealing, and cheating and law-breaking warrants the imposition of costs and sanctions pursuant to CPLR 8303A and 22 New York Code Rules and Regulations, Part 130-1. Point 11. Karamitsos asking for sanctions on Glendora is all the evidence this courts need. She knows Chief Judge Glendora knows, or Karamitsos knows, that Chief Judge Grisey, United States District Court, Southern District of New York, declared Glendora informa pauperis on August the 23rd, 1995. Glendora's sole income is Social Security. Crooked lawyers and corrupt judges have impoverished her. This is the way they have thousands of others. Sanctions on Glendora become meaningless. Also, collecting any judgment costs becomes meaningless. Koza did not include the required statement with the judgment he sent Glendora, another obloquy from Judge Wood to Koza. CPLR 8303A does not apply to Glendora. She has no money or property. It is not Glendora's appeal that is frivolous. It is defendant's defense that is frivolous. The record speaks for itself. Hundreds of pages of defense frivolity. Their record is grotesque, just as it is their political continuance